Today we're pleased to have Mark Williams, who is the president of the Michigan Certified Development Corporation. And MCDC is the leading provider of SBA 504 loans in the state of Michigan. They operate 5 offices throughout the state, and Mark has been with them for nearly 5 years. We also have Alex Morris, who is the advocacy manager for the Michigan Bankers Association, and he's been with MBA for just under 2 years. Prior to that, well, he's spent about 3 years working in state legislation or legislative as well. And we also have Brian Spratt, who is Chief Operating Officer and Chief Risk Officer with North Star Financial Group, North Star Bank, and Grand Rapids Community Bank. He's been there about 3.5 years. Prior to that time, he served as assistant director and really was chief bank examiner with the Michigan Department of Insurance and Financial Services Office of Banking. Just a little bit of housekeeping before we open the floor to our panelists. We do have everyone muted right now because there are quite a few of you, almost 60 participants on the call. We're going to keep you muted, but if you have questions, please type them into the chat function. And after our panelists kind of do a little bit of presentation and share some information with you guys, we will be reading that chat, all of those questions, try to get as many of them as we can get answered for you today. So just either type your question into the chat to everyone or to me. My name is Jody, and we will try to get as many of those questions answered as we can. All right, with that, I am going to turn it over to Mark Williams.
Thanks, Jody. Appreciate it. Welcome, everyone. And it's, I don't know where everyone is around the state, but I'm in Hazlet, and it was just snowing and sleeting here. So I closed the blind behind me so I don't have to see that. But it's been an interesting time in the business, the small business world these days. So I've got a presentation that Alex and I are both on a task force through MBA and Community Bankers of Michigan, and several bankers and non-bankers, but providers to the industry alike have formed a task force a couple weeks ago regarding the CARES Act and everything going on with that. So I'm going to share the slide deck, which we'll make available to everyone. Jody has it, and she'll make sure that everyone gets this. And this is provided I can figure out how to share my screen appropriately. So can you guys see that or no?
Yep, we can see it now.
You see this? The CARES Act?
Yep, there it is.
Awesome. All right, that big blue and white page, and then we got a table of contents. I'm going to hit on a couple of features of the CARES Act as it relates to small business. One of the things was on current SBA loan programs. For every borrower that had an SBA 7A, 504, Community Advantage, which is a type of 7A loan, or a micro loan, the Act provided for a 6-month payment relief. Some have called it subsidy, some have called it waiver. In actuality, what it is the SBA is paying the borrower's payments for them for the next 6 months, beginning with the date of enactment of the Act. And that was date of that enactment was on 3/27. So for any of your clients or yourselves that may have a 504 loan, the April 1st payment was payment number 1, and it will continue through for the next 5 payments thereafter. For your clients who may have a 7A loan, if they made their payment for the March 27th or March 28th that was due, or April 1st, then the banks are to refund those, the lenders are to refund those payments back, because the SBA will be making those payments on their behalf. That's on everyone that has an existing loan, that's on regular servicing and not on deferment. If their loan was on deferment, like at MCDC, we had several borrowers who were very proactive with the COVID-19 situation, and we got them on deferment beginning with the April 1st payment. Then what the SBA has allowed a special dispensation for us to be able to cancel their deferment early after even just 1 month, so that then they can take advantage of the payment relief. If they choose not to, they'll get the payment relief once they're off deferment. In addition to that, any new loans, 7A or 504 loans that are made within 6 months of date of the enactment of the Act will also get their first 6 monthly payments made on their behalf. So really, quite a good situation for a lot of borrowers who were genuinely impacted and in a very, very negative way regarding the situation with the shutdown and all of that. So the SBA is stepping up and making those payments. And, they were a little late in getting the announcement out, like on 5/37 on March 31st, they let us know that they were actually going to make the April 1st payment, and going, yeah, that was, timing, it's good timing. Also, the Act referenced the Economic Injury Disaster Loan Program, and some of you and your clients, I'm sure, have heard of this. This came out actually before the CARES Act was signed into law. And what that is through the SBA's Disaster Loan Program, which is a long-standing program. You usually hear about it with hurricanes, floods, things like that. It's the same program or similar in function, but they call it the Economic Injury Disaster Loan. And yourselves or a small business could log into the SBA's website at sba.gov/disaster and apply for an economic injury development loan. These are loans that are directly made by the SBA, not through a lending institution. Pardon me. They are for up to $2 million with terms up to 30 years. And the way that system works is you make your application online. An SBA loan officer would pick up the application, and then in essence, they make an offer and say, here's what we'll do for you. And you can choose to accept it or decline it, or your clients could do that. If they accept it, it carries an interest rate, if they're a for-profit entity, of 3.75%. And if it's a nonprofit, it is 2.75%. Pardon me, if those loans are $25,000 or less, there's no collateral and no personal guarantees. If they're for more than $25,000, then they'll take all available collateral. They'll put a lien on homes, all business assets. They don't care if there's even any equity in them. They're just going to put a lien on everything. And then that's for if the loan's more than $25,000. The speed of turnaround we heard was 21 to 30 days. I haven't heard from anyone that anything any different than that, but I also haven't heard that anyone's gotten their loan yet. So we'll see. And this does not carry any forgiveness of debt. This EIDL is a loan that will be repaid over time to the SBA directly. And there again is the website on the sheet as to where one can apply for that. In addition to the EIDL is a grant program, also referred to in a lot of the documentation by the SBA and on Treasury as a loan advance program. It's a forgivable loan advance. So anyone that applies for an EIDL, once their loan is processed into the system, not when they submit it, but when it's processed into the system, will be automatically eligible for a $10,000 grant or an advance on that loan that is forgivable and is automatic. Even if you get declined for the loan, they can still keep the $10,000 grant. So it's something that they put into place after the EIDL came into effect. Actually, the CARES Act did provide for the grant program. So that's how they're administering that. Both are applied for at sba.gov/disaster. And it's download the forms, fill them out, and then upload them. They actually took the website down a couple of different times to upgrade it. And what I've heard is it's working pretty smoothly. I had somebody tell me just the other day that they helped a business person apply, and it took 7 or 8 minutes once they were on the site. So a pretty quick process. The one that you're probably all tuned in to hear about, and then Alex and I are going to touch on it. I'm going to turn it over to Alex and let him do this, is the Paycheck Protection Program. The PPP loan that was created by the CARES Act has created a lot of consternation in the banking community right now. I'll let Alex talk a little more about that. There's a lot of information out there. So Alex, I'll turn it over to you, and I'll stop sharing my screen and give it back to you, I believe.
Sounds great. Thanks, Mark. Yeah, appreciate your update there on the two loan programs. As Mark said, this Paycheck Protection Program is probably the one that you are most interested in learning some about, and I'm certain that most of you have learned kind of the basics on that. And if you'll give me just a second, I'm going to work on sharing my screen so that you can read kind of what I'm going through. I'm not going to go through this word for word by any means, so don't be too concerned. Can you all see that?
Yes.
Okay, perfect. So just taking a look at this Paycheck Protection Program, just a few things for you to know. I know most of you will be working kind of on the other end of this, whether you're working with a bank on the back end or a business on the front end. But the PPP loans really truly are not loans if they're done correctly. I'm sure you've all seen some of the guidance that has come out from the SBA and Treasury. One thing to understand when you're working with your banks through this process is the federal government, surprise, surprise, has been an obstacle, and I'm sure Brian can share some of what that obstacle has looked like for banks. But you have lenders basically in every federally insured depository institution across the state and across the country that are working 12, 15, 18-hour days to process these loans. There is, in terms of eligibility, it's very wide and variable. There are some exceptions, but not many. Virtually the concept and desire for the SBA and Treasury that they have shared with the banking industry is that every small business and most nonprofits in the country would hopefully be eligible for these. There are some limits on the nonprofits. 501c3s, 501c19s are included, but there are a few nonprofit organizations that are not eligible. So as I scroll down here, you can kind of read and see that. I think in terms of what is most relevant to you in the PPP program is to understand that working with banks is helpful and useful, and they are willing and open to partnering with you all and looking forward to doing that to get this money out as soon as possible. The main goal is to deploy the capital as quickly and as efficiently as we can. Having said that, also understand that specifically for small community banks, we have, for example, a bank that is a $350 million bank in assets, and they have $50 million in PPP loan applications in their bank from what I understand is just from their customers. So understanding that a $350 million bank does about $70 million in lending, this specific bank per year, and we're expected with a program that rolled out on Friday to have loans dispersed and ready to go within about a 14-day period. The SBA and Treasury came out yesterday with some additional guidance that indicated that banks will need to disperse funds from these loans within 10 days of receiving approval from the SBA. So imagine a bank that does $70 million in lending in 2019 doing $50 million in lending in a 17-day period from last Friday to 17 days from then. So this is a Herculean effort. Again, certain that all of you are aware of much of this. The biggest piece of the PPP program that is bringing businesses into the fold and having interest is the fact that these are forgivable loans as long as they are used for 8 weeks of payroll expenses. The threshold in terms of how that dollar amount is used in order to make it forgivable is 75-25. That is 75% of the loan proceeds must go to eligible payroll costs. Some of those eligible payroll costs are listed here in the sheet that you have. Others are not. There's some fairly specific things. I think probably the one that has tripped folks up the most is eligible tax payroll costs. State and local taxes that are included in payroll costs for a business are eligible to be included in the loan calculation. Federal taxes are not. So FICA, FUTA, some of those things that you all are very familiar with as you do your work on a day-to-day basis. Maximum loan amount is $10 million. And you can see the loan calculation there. I'm sure you're all familiar with that. The task force that Mark mentioned has also come up with a few tools that we hope are useful, with the caveat that everything in this slide deck that you are seeing here, this is about a 30-page document that you'll get after this call is over. Everything in that document, as well as some of the other things like a payroll calculator, a PPP payroll calculator, how do you accurately include the right information and what line items should be shared, and some of the other things that banks had not received, like promissory notes, etc., all were created by this task force with the available information. And again, SBA and Treasury have kind of trickled the guidance out, and it seems every time they submit new guidance for a bank to follow, it is in some way contradictory to the guidance that came out 48 hours prior. So we have done quite a bit of work in the last 10 days, and the banking industry has been at full tilt trying to assist businesses in deploying some of this capital. But again, a significant lift, and appreciate all of you on the line, any help that you can offer. I will close that by just saying I have spoken to a number of our members who are so busy, and their lenders are so busy that they don't believe that there is time in their schedule to partner with an accounting firm or a CPA. And I've spoken to bankers who are excited and feel like they need desperately the help of an accounting firm to kind of help carry the documentation and payroll calculation lifts that are included in this. So if you're interested, if your clients are interested, I know the banks are willing to work with you, but again, understand the immense stress that the industry is under right now. And I'll let Brian speak to a little more of that now.
Good afternoon, everyone. They're a lot more polite and composed than I will be. I'll just lay it out there. Myself, I'm, as mentioned earlier, I'm Chief Operating Officer of Northstar Financial Group. Between the two banks in Michigan, we have one in Florida as well. Two banks in Michigan, one on the east side of the state, one on the west side of the state. We total 1.3 billion in total assets. We worked tirelessly over the weekend to roll this out. The statement about 50 million of PPP loans is pretty consistent with our rough estimates. A week ago, I guess a week and a half ago, when this was announced, we started talking about most likely it would be in the range of, maybe 25 million. We threw a 5% of our commercial loan book as a fudge factor. Based on early returns, it's going to be bigger than that. It's going to be actually pretty huge. The bigger issue here is not necessarily the dollar amount of loans, but each of these loans are in the range of, for us, $1 to $300,000. So we're doing $50 million of $1 to $300,000 loans in most cases, which means it's a high volume of activity. So for this call, this is just to give you perspective of what I've been working on, what the industry is working on collectively. For this call, it was the first time this month I've showered before noon. It's the first time I don't have pajama pants on right now. I have jeans on. And it's the first time I actually have a business, somewhat of a business attire on this month. It's 15 to 18 hour days. I'm sending off emails at 1 a.m. as we're doing research. The rules are changing on a daily basis from what's been published. So we're making blind best faith efforts to to engage with our customers and put out a packet of information that we can rely on at the time, but the rug gets pulled out from under us every day pretty much. So we've made decisions. I made a decision last night that we are going to dock these loans completely different than any other loan that we've ever done. This is the Wild West. It's a handshake loan, and that's what this is. And ultimately, it's on the borrower and the applicant of the borrower, even if by their business and corporate documents, not authorized to lend or seek a loan and bind the company into a loan agreement with the lender. By completing the application and signing as such, they're warranting to not just us, but the U.S. government that they're doing so. So we were going to go through our normal, somewhat of a skinny down, but normal docking process where we have executed borrowing resolutions. Because we have a rule now in my company during this time that we are allowed to swear as much as we want on any call and any time. So I'm going to use that because of the shit that's being put out there on a daily basis. Some of it's good, but it just is very challenging to keep up. We're having to adjust on the fly. So as of this morning, we have gotten through, between the two banks in Michigan, we've gotten through about 60 applications. We have about 290 left in our pipeline today, and they're coming in fast and furious still. Those average sizes I mentioned are between $100,000 and $300,000. We have 10 days from the day in which the SBA gives us approval number to basically book this loan. And with that 10 days, that means we have to dock it. We have to go through our largely stable and consistent requirements to comply with BSA. We can skinny that down as much as we can, but we're still required to under the law, and even clarified within their frequently asked questions issued by the Treasury, which is updated daily, as well as their initial final rule that they published last Thursday night, that we have some BSA requirements on us to comply with. We've elected, I mentioned, to not go with a borrowing resolution for these loans. We are going to go with a document I drafted and I sent to an attorney this morning because I drafted the first draft about 1 a.m. last night, and I figured it better have legal counsel look at it. It's a certification that that person is warranting to us that they are legally permitted to bind the company to take a loan and sign any loan agreement with us. It's not a borrowing resolution. It's a certification of authenticity of their representation. And we want to make sure that's clear. That's one example. We've got a skinny note, that's sole purpose note. We've got a, for the operations side, we're looking at a boarding sheet. You know, when we built this whole thing out, we looked at it over the weekend, what we worked on, and I was part of a team of a few of us, tried to look at how we're going to actually process the volume that we expected, which has been right in line with what we expected. Our typical commercial lending activity had to be completely flipped, and now we're looking at this as a manufacturing assembly line. And these are homogeneous with non-homogeneous inputs, meaning the different tax documentation and payroll information that's provided is unique to every business, different payroll providers, different reports. So we had to try to design a system that would allow us to move high volume of activity through as quickly as possible and try to install a quality control in the front half, not in the back half of our process. It is an extreme challenge to get through it, as well as we did not have access to the SBA's platform to load these loans until this week. We rolled out on Monday after working 35, 40 hours straight over the weekend. And as soon as we rolled it out, there was an issue with our application packet, and it exploded, and we had a lot of customers calling and complaining within 20 minutes. So we had to work backwards and try to fix some of those issues, and it's still not perfect, but it's a moving target, and we're working through it. I know some of the questions as the chat's been popping up about payroll, and I'll let somebody else jump into this as well, but it's our understanding and guidance from the ABA is that distributions of payroll through of any form is not included in the calculation. So if you have a person that owns and doesn't take a W-2 wage, rather they seek distribution of their company, that cannot be included, and we are not including it as allowable compensation under the PPP program. I don't know if anyone else has a differing opinion on that. Mark or Alex in particular.
Yeah, just unmuting. Alex, did you have a comment?
Yeah, I was just going to mention that I think to Brian's point, and I think the best way to answer that question is that each institution is going to make some decisions, as Brian laid out there, as we go, because everything is not clear and there isn't certainty necessarily on some of these things. And I think that specific item you brought up, Brian, is one of those. And I think some institutions have read that somewhat differently. And they, based on risk tolerance and business model, are going to have to make those decisions. And that's, again, why I say at the beginning, this is something that we all need to work through as a business community together, because the banks are making uncomfortable decisions that they don't really like making by edict of the federal government. So I guess that's the best way I can answer that specific question, Mark, if you had something more clear.
Yeah, the only thing is I'm looking at the interim final rule, which was issued last week or earlier this week. I don't even know. The days all run together these days. But on page 10 of that, what qualifies as payroll cost, I'll skip the first 7/8 of that answer. And then it says, and for an independent contractor or sole proprietor. Now the question is, if they own an owner of an S Corp, is that an independent contractor, sole proprietor? It says, but for an independent contractor or sole proprietor, wage, commissions, income, or net earnings from self-employment or similar compensation. Interpretation there. I would err on the side of that is eligible for the calculation if they choose to pay themselves from the distributions of profits from the company, if they're the sole owner of the company. However, it still applies to the $100,000 cap. So anything over 100,000 wouldn't qualify. So it's capped at 100 grand for the year.
And to give that just a little more clarification, we did learn just a couple of days ago that that $100,000 cap only applies to actual wages, cash wages, as opposed to the way banks were kind of looking at that beforehand. And I think that was clarified a couple of days ago, if I'm correct on that, Mark.
Yeah, and the FAQs, the Treasury issued FAQs out.
Okay, it looks like you guys have kind of touched on some of the first questions coming into chat, talking about the PPP program as it relates to sole proprietors or independent contractors that do not have payroll, just earnings to the owners.
Well, the
Go ahead.
payroll, sole proprietor or independent contractors, I don't think we're at a point right now that they can apply. I believe that starts tomorrow. Isn't that correct?
Wow.
Correct.
So we'll see more information and more changes coming out as that happens too.
We'll know the rules
Just to
next
clarify,
Thursday.
sorry, go ahead, Brian.
I was going to say, we'll know the rules for that next Thursday after we take out 300 applications.
Right, that was kind of what I was going to say is, Jody, just to clarify, yes, tomorrow is when those folks can begin applying. Whether we get additional guidance, whether the banks get additional guidance on how to do that and when it comes is unclear. And to Brian's point, the program starts tomorrow, and we may not have clarity on how to actually execute it until the middle of next week. We just don't know. So just to give that caveat, that's kind of what we're working with.
Okay, and there's a lot of questions about that in the chat with S Corps and when calculating payroll for a PPP loan for sole proprietorship that has wages, can I include up to 100,000 of Schedule C income in addition to employee wages? Can a partnership get a PPP loan based on payments to the partners, even if there are no wages? And if so, what does payroll include? For example, guarantee payments or anything else?
Our interpretation is no. It's got to be, and it's got to be the tax-paying entity itself paying direct payment through a typical salary and wages. That's how we're operating. So if it's a multi-layered organizational structure, the entity that actually has the payroll expense is the one that would be making the payment and applying. But we're applying it for each TIN is allowed to apply under the program.
Okay. Thomas is asking, why didn't the banks partner with CPAs to help them with the application process?
I mean, we're having a call with CPAs right now and asking us questions, so I don't know how much more you know. Sorry.
I think the other answer to that is twofold. Number one, I think each bank is making that decision institution by institution to find out what the best thing for them is to do, whether that is to participate and partner with a CPA firm or not. One. Two, I don't think there was enough clarity or guidance to the banks, and maybe still is not provided in the program to really understand how a partnership would benefit either entity. So I think that is part of the answer to that question. And then also, as this has rolled out, there has been, and please understand that I am certain that this is not this group on this call, but there has been a fee applied to additional agent work and understanding that banks are processing. One thing I didn't mention about the PPP loan is they're processing a loan at an interest rate of 1%, which for most banks is below cost of administering the loan. So they're virtually operating wholesale, if not at a loss, in order to administer these loans. And so incurring additional fees is a concern, a business concern that I know all of you can understand. And then we do have some folks out there who have simply partnered with businesses and sent a bill to a bank without ever communicating with the bank, which poses some issues in preparing those applications as well. So I think that, I hope that kind of covers the whole universe of why maybe that has occurred in each given circumstance for each given institution.
I think the other thing I'll throw out there is the onus is on the borrower, not the lender, to support and provide the documentation. So our level of due diligence and working through these is not deep. We're looking through the information to make sure that they are not including individuals, or they're capping individuals with salaries over the $100,000 mark. They're not including salaries and warranting to us that they're not including salaries of individuals who are foreign nationals that don't have their primary residence in the United States. And we're doing a spot check. We are not digging through, we're not spending more than probably 20 minutes on each and every application to look at our validity of the loan amount. We're doing a spot check and we're doing our best effort. And based on the recent guidance from Treasury on the FAQ, I think we are meeting their threshold of a reasonable due care standard. And that's what we're trying to shoot for. And when we're trying to process 300 applications, as and everybody wants their money now. So we're trying to move this quickly and as effectively. I'm sure, Mark, you're processing a lot of transactions. You probably have similar standards.
Yeah, we're not at the level of 300. We work with, for the CPAs on the call here, we're a lender service provider. So what we do is we have contracts with various lending institutions to basically be their SBA back room. So we'll process applications on their behalf. We're in the hundreds as far as applications that are in the queue. And we've seen them as large as $4 million and as small as $8,700. And so I said, can they know the initials EIDL? Send them over there, So, but all joking aside, it's that's it's a broad variety, as Brian say. It's just push it through. We're trying to take the tack, as we have with all of our clients, client lenders, is that we check the paperwork fairly detailed, and we want to make sure that that the borrower application is completed and signed appropriately, the lender application same, and that they've verified the payroll totals that they're using enough to satisfy the requirements, as Brian mentioned, that the SBA is giving some leniency to the lender in this, but still saying they still need to act in a manner prudent with common lending practice. So, yeah, and every bank's different. Everyone has their own standards and their own view on it. And, just the volume of applications that are being processed on a daily basis, literally 24 hours a day. I've seen questions coming in at 4 a.m. from lenders, and applications are being submitted after midnight on a regular basis. So I was going to jump to the next one, Jody, if I could.
Oh, absolutely. Go right ahead.
Chat question, because it's one that's very direct in the frequently asked questions document issued by Treasury. The question is per last roundtable, which I wasn't part of, but we were told to add FICA and Medicare match to payroll costs. No, it is absolutely not allowed. No Social Security, no federal taxes at all. No Social Security, no Medicare are eligible as payroll costs. So in essence, the only tax is state tax. It says state and local taxes, but if it's withheld from the employee's paycheck, you wouldn't add it on anyway because you're capturing it in the gross wage column. But if it's, if you're paying a tax or if your clients are paying taxes to a local or state authority, i.e. unemployment tax, that would be eligible. But not, no federal taxes whatsoever, and certainly not Social Security or Medicare.
Thank you. William says, my PPP application form is complete and my documentation is all in order. The bank I'm working with has asked us to complete an intake form, but no additional guidance yet. Will I be submitting my application directly to the loan officer at my bank? Waiting patiently for guidance from the bank, nothing yet.
I think, the bank is, all of us are developing their own channel for receiving and processing applications. There is no channel that is consistent across the organizations that I've talked to, and I've talked to a lot of banks. I know, based on my career path, I know a lot of bankers across the state and elsewhere, and so I've reached out and asked them how they're processing. Some are using central hubs, some are using technology services to file online. Some are, like we are working directly with customers and trying to process it with a quality control being managed by individuals to try to keep the flow reasonable and well contained in a specific point. So I can't answer specifically what each bank is doing because we don't have a workflow or a channel of delivery that was provided by the Treasury Department or the SBA in this process. They put it out to the public the same moment they put it out to the banks. And our ability to develop the workflow when we're getting applications submitted to us before it's even open to be accepting applications is very challenging. So we're shooting blind here, and we're making it up as we go. And I said it's a handshake loan, if nothing else, and we just have a reasonable due care standard. And I think we're trying to meet that. And as I mentioned before, we're creating forms on the fly to try to better document and support and make it clear what the obligations of the individuals applying for the application, applying for the loan are, as well as that we're not taking the extra effort to warrant that we're checking to make sure that they are who they say they are, and it's on them to do so. And if they fail to do that standard, that's punishable under law, as issued by the SBA and clarified. So each bank is doing it differently, and we're making it up as we go here, folks.
And if I can contextualize that just a little bit, Brian, appreciate that feedback from you on the ground. I think the key thing to take away from that is that that's specifically and precisely what the SBA and Treasury have asked the banks to do. They do not want the banks spending an inordinate amount of time on one particular application. They intentionally have made a process that allows the borrower to attest to what they're sharing with the bank, so that the bank can take the information, get the loan in the system, and get the dollars out to the business. So that's kind of their intention, and frankly, far be it from the banks to tell Congress and the SBA and Treasury that they're not going to do what they've asked. So I think that was probably the point I wanted to make the most there, is everything that the banks are doing in terms of trying to turn these loans around is somewhat contradictory to typical lending practices. And frankly, that's stress-inducing for a banker, because we know our federal regulators will be back in the bank in 6 and 12 months, taking a look at how these were processed, and we don't have a lot of clarity on how it's supposed to be done. So ultimately, turning these around as quickly as possible was the number one and virtually the only goal and marching order that banks received from the federal government, from the Congress, with this program.
I would even say that as we look at some of the guidance that's being issued by the Treasury on the fly here, that if we go through our normal docking and underwriting process, there might be things that would hold up individual applications, or maybe disqualify for applicants from being signing those individual applications. So that's why we've decided to not go with our typical verification process of through borrower resolution that would allow an individual the authority to bind a company to a loan agreement. Because if we get that borrowing resolution back and that applicant is not on the form, we've got an inconsistency there that potentially throws that entire packet in question. So we're trying to remove that risk at this moment. That was what we were working on last night and this morning to, in removing that risk, keep the validity of that application only and solely on the borrower, not on the borrower's authorized representative, not us.
Yeah, and William, your question, an intake form, working with 36 lenders, we've seen a variety of forms that have been created. We provided some guidance on some of those, and some of them were just using our forms, and some of them created their own. So, but they do have certain certifications that the borrowers have to make. They also need to provide their NAICS code, and one thing that is specific in here that you need to be aware of is they must provide the number of employees that they have, and that they had on February 15th, 2020, because that's the test that's going to be part of the test that's going to measure whether the loan is forgiven or not. So it's, there's pieces of information that are necessary as part of that. And yeah, every I won't say every, but many banks have created their own form of an application in addition to the lender app that they're required to complete as part of the program.
Yeah, and I'm not the one obviously inputting into the SBA system, but there are certain items and fields that are required for us to answer in the system, and as well as on our version of the application that we have to submit for each and every customer that are not questions on the actual application themselves. So we're providing that intake form, I guess is the way I'd put it, in addition to the SBA application, for solving those problems to make our ability to process the transaction much more possible.
Jamie has a question and says, we need guidance on partnership returns. Some banks are not allowing income reported on K1 and may require each partner to complete an application on their own. That doesn't seem to make sense. Thoughts on that?
Well, I like Brian's comment earlier that it's the payroll paying entity that is the applicant here. And if the partnership has the payroll and is paying wages, then the partnership can. Now, K1's obviously different. That's as an owner. and so the question is that the only way someone's being paid? They're not being paid in a paycheck on an ongoing basis. Then that makes it a little bit more, acts like a self-employed situation. And it's a little bit of a gray area. So I can certainly understand the need for guidance on that. I would say it really does depend. Do you have payroll in that entity or not, or is it strictly these are the profits of the entity and it's the only way I get paid? That's going to make it a little more challenging. And I'd say your application couldn't happen until tomorrow, and it might make more sense to each one applies on their own. But so let me say it depends. How's that? Alex, Brian?
I agree with that. That's the route that we have taken to interpretation. We do not have any hard and fast guidance from Treasury. And so we're, a lot of us are stuck making that call, but that's the decision that we've made too, that a distribution doesn't constitute a salary, even though it's treated in many cases by many business owners as a salary for tax purposes and among other reasons. But we don't think that constitutes a salary, but that would be a situation to file an application tomorrow.
Okay. George asks, I have clients that do not want to take the maximum loan amount, but bank applications that do not ask. They don't ask the requested amount. How is that being dealt with?
Ryan, if I can jump in here and then let you answer kind of how you guys are dealing with that. But in a general sense, my understanding is that the applicant does not have to take the entire amount that they are eligible to apply for. The payroll calculation simply calculates the max, and it would be up to that business. And again, clarifying that the application that is coming from the bank is not an application created by the bank. This is an application created by SBA and Treasury for this program. And so that you're correct, that question is not asked on that application, and it's something that should be specifically documented and indicated by the business owner in the application process.
Yeah, that's how we're doing is whatever they request, as long as they qualify for it, we'll process it as they request.
Okay. Thomas asks, do you plan to cover what the process will be for determining what will be forgiven?
That's weeks down the road. I have time.
I'll take a shot at it. There's been a little bit of guidance coming out from the SBA, and of course, is not atypical to SBA guidance. It seems to run contradictory to what we've read and been reported up till now. That said, it's payroll, anything paid for payroll-related costs, same as the calculation for the maximum loan amount, during the 8-week period subsequent to when the loan was paid, plus rent or interest on mortgage payments, interest on other debt, and utilities. So those are the classifications. Here's the limitation. 75% of the loan proceeds at minimum must have been used for payroll related costs, or the loan forgiveness will be repaired down to a lower level. So have to use 75% or more for payroll. And something came out from SBA the other day that it was SBA's preference all along to only be used for payroll. They allow rent, utilities, and mortgage interest as other uses as necessitated, because you may not have the full amount of payroll. Now you must also, the borrowers or yourselves or your clients must also employ the same number of people. So keep their employees on payroll and pay them the same amount within 75% of their regular wage. So it's kind of that 75% seems to be a magic threshold for forgiveness of the debt. And if you can achieve that and document that it was used for those purposes during the forgiveness application process, which they did put on the lender to make sure that it's, that they're getting that proper documentation, then the loan would be forgiven in full.
one caveat, the guidance that was issued, interim final rule last week, only puts the lender as a responsibility of collecting the information, not comprehensively recalculating and checking it. So we can rely on, once again, reasonable certifications and reasonable documentation to reasonably demonstrate the funds were used properly.
Yep, good clarification.
Michael has two questions. The first is, if our clients have filed their applications and we determine they made errors in calculating payroll costs, can they amend their applications?
Yes.
Yes.
Good. The next is, there's a question on the application asking if we've received anything from an EIDL loan. How do we answer that if they've applied for an EIDL before 4/2/20 and haven't received anything?
Answer it as accurately at the time of application as you can. The answer is no, haven't received anything. Because remember, an EIDL loan can be declined. Matter of fact, you're prohibited from getting one from each at the same time. So if you have an EIDL loan and you want to refinance it into the PPP, that's fine. But if you wanted to get both, then that you can't do that. Once you get a PPP loan, you wouldn't be eligible for an EIDL, is my understanding.
That's my understanding as well, but just a small clarification on that. If your client has applied for the EIDL loan and has received the $10,000 grant portion of that program, my understanding, and correct me if I'm wrong, Mark, but I think this is correct, they can withdraw then that application for the EIDL, keep the $10,000 grant, and apply for a PPP. They would simply take that $10,000 off of the total amount that the maximum allowable for their PPP, because they've already received that, and then they would be eligible for a PPP.
Okay.
I think they
Thank
actually.
you. That helps me, because I just had a question pop up in my inbox for that very thing.
I think they actually, the interesting thing is I think we interpreted that differently during the task force did. And it's actually, I'm looking for it under, wasn't under maybe it was in the interim final rule. Yeah, in the interim final rule on page 10. So if they, I don't want to go through the whole thing, but if the average monthly payroll is 100,000 multiplied by 2.5, that's 250. Then they add the EIDL loan of $10,000, so their total eligibility is 260. So they don't subtract it; they actually add it. It's increasing by $10,000 the maximum loan amount, and then they refinance the EIDL into the PPP. So,
that's how it looks like it to me for the lender application.
So Brian, you were breaking up. What was that?
The lender application, it appears that
Uh-oh, I think Brian has frozen up on us.
So just to pick up where Brian left off until we get him back, Mark, I think your understanding there is correct in the case that the borrower had not received the $10,000 yet. Is that what you're saying accurately?
Well, I'm looking at their examples, and their examples sometimes leave a little to be desired because they just keep using that same $10,000, which can be confused with the grant, the loan advance. So, yeah, but it does say annual payroll, subtract those that are over 100,000. So you get your average monthly qualifying payroll and multiply by 2.5, and then add EIDL loan of $10,000. So
Okay.
Okay, Jeff, I think we've kind of discussed this a little bit, but Jeff asks, my regional bank said that they received 16,000 applications and will be calling customers based on order received in the queue. They've not requested any info from us. Normal? It sounds like that answer to that is, yep, that's pretty normal at this point. Everybody's a little overwhelmed.
Yes, I think that's probably the case.
Jamie asks, I have a client that has 140 employees that have permanent residence in the US. However, they are a subsidiary or branch of a foreign corporation having many other subsidiaries. If the entire international group is over 500 employees, does that throw the client out of the PPP?
Wow.
Told you guys we'd have some really good specific questions for you.
Yeah, that's a great question. As far as what I know and the way I'm reading it, in what's available, I believe that it would, but that's, I think, really unclear. Mark, do you have any more specific answer to that question?
No, I don't really. I'm trying to look at the interim final rule, just, because the question in there is, is how do I determine if I'm eligible? Small business, so the issue might be there is they have subsidiaries, they have affiliates in essence. And with those affiliates, they're over 500 employees, so they wouldn't be eligible anyway.
Right.
That would be the one that may kick it out, in addition to the fact that it's an international, owned by an international firm. But I would.
And that may be covered in the SBA affiliation guidance as well, which is different from the interim final rule. And that's something that, if needed, we can share after the call to include with the slide deck that we're going to share as well.
Yeah.
And that affiliation information can be found at sba.gov.
Yeah, I've had some better luck, it seems, finding it at treasury.gov. It seems it's really accessible on treasury.gov, and then there's a big red band across the top that says COVID-19. Click on that, and all these forms are right there, and you can access them for yourself. And if you're bored, you can read them. And if you're an insomniac, they probably won't be for after a while. So, and I've read them too many times. I've never read anything coming out of Congress as often as I've read this CARES Act. And and I didn't read the whole thing front to back, but it's been crazy. So
it makes you not like Congress very much.
It isn't the only thing.
Brian's back. We have Jerry and also Kurt have mentioned the rules have state that banks can receive up to 5% of the loans administered. And then Kurt kind of refers to that he's heard the same thing as Jerry about the 5%, yet haven't read it anywhere myself. Are you guys familiar with anything about that?
So the 5% that you're reading is not a percentage of the loan proceeds. It's simply, and it's a 1%, 3%, or 5%, depending on the size of the loan. And that really is basically just covering the bank's cost. And that is a fee that's being paid by the SBA to the bank in order for them to issue the loan at a 1% interest fee. So that fee income is basically covering the administration costs for the bank. Is that a fair interpretation, Brian?
That's absolutely consistent with.
Yeah, SBA is paying that. There are no fees to the borrower in this.
Right.
All the fees are paid by the SBA.
Right.
Yeah, and we don't get a share of the loan. We just get a we get paid for doing it.
Okay. This is kind of a broad question, so I may ask Roy to specify a little bit more when he asks, does anyone have any experience with the EIDL program? So if you've got something specific, Roy, that you'd like to know about it. Yeah,
I addressed what I know about it in my presentation, and know others, people that have applied for it, but I can't tell you anyone that's received a loan from it yet. I have not heard that. So.
Okay. Jamie, kind of coming back to the question about partnerships, and I think he's clarifying a little bit here. The partnership has the payroll and income subject to the self-employment income. I don't know if that changes the conversation at all. This one from Lisa. Will recognition bonus paid in the 8 weeks or 8-week period subsequent to receipt of proceeds be included in compensation for loan forgiveness calculation? I don't see any exclusions. The bonus. Curious if you have.
That's a great question, and I've received that question from a number of banks. We're still working on SBA to get clarity on that. My read of what we currently have available now is yes, it seems like a bonus would count as a payroll cost. And so if it's expended as a payroll cost in that 8 weeks, that would count. But again, that's simply my read of the available guidance, and it is not specifically made clear. So banks may treat that differently depending, again, on some of the way that they're operating this program.
Okay, for clarification again from William, want to be sure I heard correctly. The employer share of FICA and Medicare is not included in the average payroll cost calculation. I too had received guidance that it can be included. I'll need to correct my application if there is certainty on this point.
You heard it correctly. It is not to be included.
Okay, that is good information. Jamie. Hey, thanks, Jamie. Don't need to follow up on my partnership question that I already followed up on. Thanks, Jamie. Greg, clarification. Does the 8-week period begin at time of funding?
That's the way I understand it.
Yes.
Okay. Michael asks, what's the procedure for amending the PPP loan application?
Send it back to the customer, they amend it, and then they send it back, and we process.
Yeah, in the borrower, if it's one of your clients or yourself, get with your lender and say, hey, I want to amend my application, and they'll do so.
Yeah.
Okay, and Roy, going back to the conversation about the PPP application, he says you add the EIDL net of advance. So that is his understanding of that as well.
Right. Oh, net of the $10,000.
Right.
Yeah. Yeah.
Right.
Yeah, and that was the next question too, net of advance. Okay. Oops, I'm trying to get my chat to scroll down here. It doesn't want to move. Sorry, my technical difficulties over here. Jamie, I don't know that I believe you, but that's okay. That's what we're here for, because he says, final question, promise. There have been many questions regarding the timing of the acceptance or funding of the loan. Many borrowers want to defer to a time closer to them resuming business operations to the start of the 8 weeks. Any thoughts on this?
Yeah, we've heard from several people that same question. Now, the guidance right now is the loan must have an initial disbursement within 10 days and final disbursement within 2 months. So they could, in theory, if a lender is willing to go through that. I think, I don't know if Brian said it or if Alex referenced it, that, there are some that are doing it as draws. As they need it, which is fine. It just seems like it's a lot of paperwork and a lot of a headache on the lender's part. But at the same time, if they're willing to offer that, that's great. But they must disperse, make the first disbursement on the loan within 10 days of the approval of the loan, not just the signing of the loan, but the approval of the loan.
Right. And the way we're doing it is we're going to disperse it all most likely into a bank account of their choosing at our institution, and they are then responsible themselves solely to manage the cash flow ins and outs of that account and the tracking of that information when they go to submit for forgiveness of the portion of the loan that they can forgive.
And to your point, Brian, I mean, it's not costing them anything. It's 1% to the bank paid by the SBA.
Yeah, well, I think we do have to charge them 1% interest rate with the payment deferred for 6 months, and then as we understand it, amortized over the remaining 18 months.
Right.
But 1% is pretty darn cheap money. And, you know, I have a couple friends, you know, that operate businesses, and they said, well, we're not operational. I said, I would recommend getting your name in and getting an application in. And there's nothing to say that you have to spend the money within minutes of getting it. You have 8 weeks to do it. And then if you don't spend it, you can return it. So it's a pretty low risk operation for the borrower. On top of it, if they do everything right, they don't misuse the funds.
I would add a caveat to just make sure that you are advising your clients, because there is that clause in there that the loan must be dispersed within 2 months, that if the bank is going to accommodate a draw setup, that loan becomes not forgivable if your client does not spend those payroll dollars within the 2 months. So if they're asking for a draw that pushes up to that 8 weeks, that 8-week clock begins ticking upon the first draw. So if they're going to take a draw 8 weeks in to finish the loan, that makes it pretty difficult to spend the dollars, which then makes it non-forgivable.
Good point. From Michael, if you have a profit sharing plan, do you use 1/12 of the annual amount?
I'm assuming so. Yeah. I mean, if it's part of the eligible compensation and retirement benefit packages that you have for your staff, then 1/12 times 2.5.
Okay. From Allison, my client pays monthly payroll. If we receive funds after we process the payroll, we might only process one payroll in those 8 weeks. How do we handle this? Wait to get funds? So they pay monthly payroll. They receive the funds after we process the payroll. They might only process one payroll in the 8-week time period.
Well, I think Alex just addressed that. You know, they want to make sure that they get the funds, and they might have to force a payroll, you know, a few days in advance to make sure that they meet that 8-week guideline.
Or consider offering a bonus between payrolls. If that expenditure is made on payroll costs, my understanding is that would be an eligible payroll cost under the program. And so if you pay monthly and a paycheck comes 3 weeks after the loan is dispersed, and then you know, you give a bonus 2 weeks later, I understand that would qualify.
Okay. From Kurt, a forward-looking part though from a client was, quote, what if still not better after the 8 weeks and even by June 30th? We'll still qualify for forgiveness, and then I'll need more funds to continue at that time. I told them that this is all to be determined, and I'm guessing more funding might get made available by Congress and or the rules amended. From Jamie, another comment, thought I read it was paid or incurred payroll would have been earned during that time period.
Jamie said he's done asking questions.
I told you that Jamie probably would pop back up. We know Jamie pretty well around here, and he's got some very thoughtful questions. He said, "Oh, technically not a question." Any thoughts on that though? Thought that I read. He said he thought he'd read it was either paid or incurred payroll during that period. Maybe.
I would have to dig into it personally. I'd have to research it right now. I don't have that off the top of my head.
Okay. I have a question, although this we kind of discussed early on about, so this one came in via email. Self-employed filing for unemployment insurance under PPP on April 10th, specifically medical employees for hospitals, nursing homes, etc. But that is based off of the independent contractor, and that we won't know much more about until after tomorrow for sure, correct?
After next week.
After next week.
Okay.
Okay.
They can apply tomorrow, but we won't know what's required until after next week.
Okay.
Jody, if we can just go back, I think Kurt's question, I think you read it, but we didn't really give an answer regarding the 8 weeks qualify for forgiveness and then they need more funds on what that business should do. I think the best advice that you can give them is if they qualify for the PPP program and they keep their employees on for that 8 weeks, every dollar that they spend from the PPP program is a dollar less that they have to then leverage later on to keep the business going. So the point of this program is to give businesses like that a chance. So it may not cover everything that you need to keep rolling and keep the business open. And I'm certain that the bank will work with you on additional loaned funds if that's something you need. But certainly don't discourage them from participating in the program if they don't believe it's going to cover all of their expenses to keep them open before this whole thing is over. That would just be my thought.
Yeah, and the Federal Reserve just announced another, what, 230 billion for small business and something today. I looked at it.
I think it was 2.3
trillion. Sorry.
Yeah.
Well, yeah, 2.3 trillion in funding for households and local governments. So, the common theme coming out of Washington that I've heard, we're not done yet. So, when I say we're not done, they're not done with funding because we're not done with the issues that we're going through right now. So,
yeah.
Right.
There's no playbook for this. There's no playbook for this. A lot of the questions are really seeking the same issues or solutions to those questions that we are asking ourselves.
Right.
And I should have said it at the beginning. I think I did. We're making this shit up as we go.
Michael points out the employee retention credit under the CARES Act would work after the 8 weeks if the business is not back. See percentages. Kurt, yes, I did. Thanks. They trying to start it. Okay, so Kurt, in response to your response, yes, I did. Thanks. They were simply trying to time when to start it, especially if this might go longer. I advise them not to mess with the timing. But I've seen sizable CPA firms advising clients to try and time it to later. He's feeling that might be a bit irresponsible. I have another question coming in from email that says, needing more guidance from the group on the self-employed PPP. Wouldn't they apply to the state unemployment office instead of a bank? Is there a standard federal form yet or web page template? Or is the answer that that's coming tomorrow?
Yep.
Okay.
We'll see.
If they can clarify the question, if that's possible a little bit, only because I'm not sure why that individual would go to the state unemployment office. And Mark, I don't know if this is accurate or not, but is there some, especially with the self-employed individual, and maybe we don't know this yet, some disqualification if they are on state unemployment to apply for the PPP?
Yeah, it's a good question. I don't think we don't have that guidance at this point.
Answer yet. Okay.
Jamie wanted to make sure that he thanked all of you before he hops off. And he says, good luck and welcome to our tax season. Eric, also
tax season was bumped. Tax season was bumped to the summer. If you don't have anything to work on, you can help me.
Eric says, also to follow up on Kurt's question, if they take the PPP loan and pay their employees for 8 weeks and then things are not doing better, I don't think there's anything wrong with having the employees be furloughed again, where they get to collect unemployment again. And I'm looking to see if Mark, who had emailed me, has followed up with another email. I don't see one yet. Checking my emails to make sure I didn't miss any. I think we hit the bottom of the chat. So we're kind of wrapping up here. If anybody has any additional questions, I encourage you to type them quickly into the chat. Otherwise, I just want to thank our panelists. We know that this is a stressful time for all of you. And like Brian has mentioned, that things are changing, and you guys are doing the best you can to get the money out where it needs to be as quickly as possible to support small business here in Michigan. And that is so appreciated. All the hours that you guys are putting in and reading into this and helping decipher it and to help our members help their clients through this difficult time. We appreciate you taking your time out of your busy days to be here to answer some of these questions. And I know that the information is going to get out to small businesses in Michigan through our members too, and hopefully that can help make your jobs a little bit easier. We do have...
I think you misquoted me.
Did
I didn't say all that nice thing. I just said we're making this shit up on the fly.
Well, I paraphrased a little bit. I do have another question here from Eric. I may have missed the answer, but if you pay employees bonuses during the 8 weeks, I think you can include those dollars in payroll forgiveness calculation. Is that correct with bonuses?
I think the understanding that I have currently is yes. Whether we get more clarification on that, I'll say this, it is not laid out clearly in the guidance that it is included. It's also not laid out clearly in the guidance that it is not included. So how's that for a non-answer?
Yeah, and I think somebody else referenced it in their follow-up comment to that was, they haven't said that you're limited, they limited the maximum loan amount per employee to 100,000. So do we have to limit the payouts the same, to those same employees? What about a bonus? If it's annualized, would be more than that. Just be a little bit cautious about that. Wouldn't want all of a sudden, and you have to maintain your number of employees as well during that 8-week time frame. So you just want to be a little cautious. But it's kind of like Alex mentioned with the bonus payroll for those that get paid monthly. You might just need to do that just to get the money out the door and comply with the program requirements. So a bonus in that setting to me would be fine.
Yeah.
More questions coming in from James. I know franchises can be considered standalone entities if their franchisor is listed. We are an auto dealer group with various brands, and last I checked, many were not yet out there. But I heard all manufacturers were planning to apply or add theirs to the list. Any info on this? Each dealership is a separate entity with common ownership.
That's interesting. We did hear that all of a sudden GM got on the franchise directory, so all of the GM dealers throughout the country could have access to the PPP loan program, because up until that time they had always resisted. They didn't want it to be part of, for whatever reason, I don't know why, but GM, because of this availability of a couple $100 billion, they said, we'll give, let's make this work. And so they got with the SBA council and got their franchise agreement approved. So if that's kind of what you're referencing, if it's one of the OEMs, then, yeah, but if it's a dealer group that's considered a franchise, that's a different issue. And somebody needs to be talking to SBA in the franchise council area. And getting with them to make sure that can work. And if somebody wants to reach out to me, I can provide the email for that person that runs that. So.
Great. I just want to remind everyone again too that the documents that the gentlemen have provided on their screens, we will make available after this. At some point, it will either be included with the playback of the roundtable. This is being recorded, and all of the playbacks of all the roundtables are available on our website, micpa.org, under the COVID-19 resource page. So if you missed any of the 3 discussions last week, they're there. This one will be made available as well, and the documentation. A couple more comments here from Eric. I agree the guidance is very vague. I appreciate and understand that non-answer, Alex. And then also just thanks to everyone. This was one of the best forums to get real-time questions answered that Eric has come across. So we appreciate that, Eric. We're trying really hard to get you the information that you need to do your job and be helpful to your clients. And James said, yep, you answered the question. I'll keep checking, and wants to thank everyone. So again, I want to echo our members. Thank you. Thanks so much for making yourself available today and making the resources available. I know that there'll probably be some follow-up questions to this too, so I may shoot some more out to you as they come across. But all of you, thank you for your time. And
Yeah.
those of you on the call, please remember that next Friday we'll be doing another roundtable discussion. That one will be with Leon Lebrecq, Wayne Titus, and Mark Rogers, and we'll be talking about what to do in a down market as we're in right now, some practical guidance through that. Thanks, everyone.
All right.
Have a great weekend.
Thanks,
And,
Joey. Thanks, everyone.
Take
Thank
care.
you.
We'll get through this together.
Yep. All right. Take care, everyone. Bye-bye.
Bye.